The next case to come before us in the state of Ohio would be Jordan Michael Jarvis. You will have up to 15 minutes to present your argument. Please do not use the names of children or minors or victims, should that be relevant. Also, please, you can use in that instance general terms or initials. And please stay behind the podium. As you know, these are being recorded, and keep your voice up. And we have read your brief, and we are ready to proceed when you are, Attorney Buchanan.
Thank you, Your Honors. May it please the court. I am Attorney Wesley Buchanan. I have the privilege of representing Jordan Jarvis, who is the appellant in this matter. I'm used to reserving time, but as noted, the government has waived their oral arguments, so we'll take the full time, subject to the panel's questioning. At the outset, Jordan does note that no motion to dismiss was filed by his trial counsel, and so the court will either have to find plain error in that regard, that it was a jurisdictional defect, or that it was ineffective assistance of counsel as far as Jordan's concern is. In addition, Jordan had filed this motion to stay because he had, in Jordan's argument, he had raised the constitutionality of the Reagan-Tobes law. However, due to the indeterminate sentencing. However, the Ohio Supreme Court has since solved that issue for us in State v. Hacker, and there was another case, but that was 2023 Ohio 2535. So as far as Jordan is concerned, as his brief did raise the constitutional issues, even though they weren't raised at the trial court level, the Ohio Supreme Court has since put that argument to rest, at least for the time being. At the outset here, Jordan notes that as an inmate, he did what he was required to do under 2941-401, and colloquially called the notice of availability, where he wanted to dispose of the pending cases that he had against him and everything else like that. The docket reveals that in March, the letter to the prosecutor that was filed with the court on April 11th, 2022, was dated in March, and that's part of this court's record, and that's part of the...
But was that actually mailed to the prosecutor's office?
That is something that I don't know, or if it was ever resolved at the trial court level. The statute puts the burden on the warden to do so. In this court case, this court actually...
But doesn't the defendant fill out the form that the warden has to look to send out notice?
So, and that's exactly what happened. In the docket, you'll see that Jordan did fill out the form, presented it to the warden, and the warden took it from there, pursuant to the ODRC procedures, and then mailed it to the trial court, which is the Summit County Court of Common Pleas, and to the prosecutor. And that was the requirement that the statute imposes. And so Jordan did live up to his end of the bargain.
But doesn't he put in the addresses as well?
As far as what he fills out at the prison,
Right.
At the prison, he fills out what court it has to go to, and then I believe that he puts in also the Summit County prosecutor.
Right.
And
In this case, he didn't put the prosecutor's address. He put the court's address.
He did put the court's address, but he did put I think he did put the Summit County prosecutor, which was listed in the docket on the letter from the warden. And so the warden, under the statute, which is clear and ambiguous, Jordan is also noting State v. Williams, which he did cite in his brief, is out of this court in State v. Williams, 2021 Ohio 4469. Jordan did what he had to do, fill out the paperwork, and then the warden, who is also part of the executive branch, has to notify the court and the prosecutor. Now, there's no mechanism in the statute that says, Mr. Warden, Mrs. Warden, that you have to show how you've done so. The statute says the warden does that. So typically in the filing, you'll have a certificate of service, a proof of service, and everything else like that. So what the warden did here was mail it from ODRC to the Summit County Court of Common Pleas, which is electronic filing. However, since it's a paper filing from an inmate, my understanding from the clerk's office is that they scanned it and they notified everybody pursuant to their electronic means, which in this case would have included the Summit County Prosecutor's Office. And that happened on April 11th, 2022. So under the statute, that gave the court and the prosecutor's office 180 days to bring Jordan up to trial to resolve those differences. And again, this court in State v. McGowan, which both the government and Jordan cite, that's 2000 Westlaw 799-099, confirmed that Jordan had to do was show that written notice was delivered to both the prosecuting attorney and the appropriate court. Here, he did that. And that's what Jordan's submission would be, is he did what he needed to do as far as an inmate is in the institution. Because as far as not being legally trained, there's a form that is promulgated by the Ohio Department of Rehabilitation and Corrections, which is the notice of availability that they fill out all the information in. Jordan filled that information out, provided it to the warden, and the warden is under an obligation to then send it to the court and the prosecutor's office. So, and there's evidence that Jordan did what he had to do. And so, at least in strictly applying the rule, this court has to balance the rule of lenity, which means the ball bounces towards Jordan here, but also the strict construction of the statute, which says that the warden had an obligation to do what they had to do. So at least Jordan would at least present to this court that because he did what he needed to do, that event triggered the time requirement in 2941-401, and April 11th plus 180 days was listed in Jordan's brief, which is a calendaring thing, which is the court can do so. In addition, as far as Jordan's sentence was concerned, the court did impose consecutive sentence, and that's why this is an important thing to bring up as far as Jordan.
That was my question too. In reading the transcript in the journal entry, it looks like it's concurrent.
It looked like it was consecutive. I mean, from Jordan's perspective, he thought it was consecutive. And I believe that in the government's brief that they responded to, they indicated that there was an issue with that as well. Because I believe on the last page of 14 of their brief, the trial court did not make, or it was cloudy, let's say it's cloudy at best, that the trial court did not make one of the findings in 2929-14 C4, and the government, at least in their brief on page 14, I think it was the last sentence, said, in the alternative, this should be remanded for a limited purpose for the trial court to either make those findings or not. Does that answer the court's question?
No, I don't know how you argue with a journal entry and a judge saying that it's concurrent, and how there would have to be any findings.
I agree, absolutely. And so if it is concurrent time, which that may be the case here, then Jordan's arguments would just mainly rest on his speedy trial arguments that have been presented to the case here. So that's exactly what Jordan did, because mainly, and again, not to waste too much of the court's time, there was the constitutional argument from Regatokes, however, the Ohio Supreme Court did resolve that for us. So as far as Jordan's concern is, he believes that the speedy trial clock had run, which would divest the trial court of subject matter jurisdiction, which, as this court knows, you can raise jurisdiction at any time during a case, including on the first time on appeal. And he would also at least note that no motion to dismiss was filed at the trial court level. So with those arguments, if the panel does not have any other questions, Jordan would ask that this court find that the trial court erred by not adhering to the statutory speedy trial and enter judgment accordingly.
Any further questions from the panel?
No.
Okay, thank you very much for your presentation. The court will take the matter under advisement and issue a decision in due course. On the day that it is released, the clerk of courts will mail a copy of it to you, and the opinions will also be posted on the Ohio Supreme Court website.
Jordan, thanks the panel for its time. Thank you.
Thank you.